criminal law, and welcome to the start of the second module of the semester. In the last lecture, we wrapped up our first Foundations of Criminal Law module. In the process, we learned about what the criminal law is, where it comes from, and the primary justifications for imposing criminal liability and punishment. We also discussed the legality principle, which we use to understand the important topics of criminal codification, statutory interpretation, and the void for vagueness doctrine. So hopefully, at this point in the semester, you now have a pretty good grasp of some of the criminal law's foundational ideas. And you now also have a little experience performing some of the criminal law's most fundamental practices. That is, arguing about criminal sentences in individual cases, justifying generally applicable criminal laws, and interpreting unclear statutory terms and phrases. With all this under our belt, we're now ready to dig into the actual doctrine of substantive criminal law and to begin the black letter law portion of the class. That's what we're going to be doing in the second module of the semester, which focuses on the most basic ingredients of liability in criminal cases, what we're going to refer to as the elements of liability. There are 5 main elements of liability that we're going to be learning about in this module. The first is the voluntary act requirement. The second is mens rea, or the guilty mind. The third is social harm. The fourth is causation. And the fifth is the concurrence requirement. We're going to study each of these elements individually, and in the process, we'll explore a number of important subtopics, such as omission liability and the law of intoxication. We'll also briefly encounter a range of different criminal offenses. Then, at the end of the module, we're going to bring everything we've learned together into a 5-part elemental framework that we can use to analyze the existence of criminal liability in individual cases. We'll return to this framework throughout the semester, and it's also going to play an important role in the exam. So, this is a pretty important module. In an important sense, everything we're going to do in the future will build on what we learn here. So I'm going to do everything I can on my end to make the material as clear and accessible as possible. At the same time, I'm going to ask you to do whatever you can to make sure you're understanding the material. Don't hesitate to ask questions, attend office hours, and review to your heart's content. Sound good? I hope so. So with that, we're going to begin this new module with discussion of the first element of liability, the voluntary act requirement. As I think you'll see, the voluntary act requirement's a reasonably straightforward topic. But, like all areas of substantive criminal law, things can still get challenging in borderline cases. And there's also an important exception to the voluntary act requirement, which we'll spend some time exploring in this recording: omission liability for people who violate legal duties. I'm also going to use a part of today's lecture as a jumping off point for exploring the relationship between the common law and the model penal code, which is going to be a recurring theme in this class. Although many first-year criminal law courses present an imaginary world in which there are common law jurisdictions and model penal code jurisdictions, the reality of legislative practice is both a lot more interesting and complicated. As we'll discuss, just about every jurisdiction's criminal code involves a mishmash of common law and MPC elements. And that mishmash is what we'll be focusing on in this class, because it's what the real world of criminal practice requires. So, stay tuned. Okay, so there are 3 main learning objectives for today's lecture. First, we're going to understand the requirement of a voluntary act. In the process, we'll discuss why it exists, where it comes from, and how it applies to individual cases. Second, we're going to learn about the omission exception to the voluntary act requirement, which applies to situations involving omissions to fulfill legal rather than just moral duties. Third and finally, we're going to use the voluntary act requirement to understand the relationship between the common law and the model penal code and individual jurisdictions and U.S. criminal codes. So with that, let's begin our discussion of the general requirement of voluntary act at the very beginning. In the criminal law, there are some general requirements that must be met for someone to be convicted of a crime. These requirements are general in the sense that they apply to all, or at least most, prosecutions, regardless of the kind of offense that's being charged. Which is to say, whether the government is bringing a case for murder, rape, or theft, there are some universal things that typically need to be proven to establish liability. These universal things are the elements of liability. One of those elements, and maybe the most basic element, is what we're going to focus on today, the voluntary act requirement. This requirement basically does what the label suggests. It limits criminal liability to people who've engaged in a voluntary act, such as, for example, willingly pulling the trigger of a gun, snatching a wallet, or throwing a punch. This isn't a particularly demanding requirement. As we'll discuss, any bodily movement that's the product of conscious effort and determination will suffice. But it nonetheless is a requirement that must typically be met before criminal liability can be imposed. So, for example, someone might have detailed thoughts about committing heinous atrocities against an innocent group of schoolchildren. Or a strong wind might blow someone's arm into the face of an elderly grandparent, causing a massive amount of harm and suffering in the process. But however heinous someone's bad thoughts are, or however harmful the results of a wind force punch might be, bad thoughts or involuntary conduct aren't typically a sufficient basis for imposing criminal liability and punishment. Okay, so those are the broad strokes of the Voluntary Act requirement. Now I want to dig into the details with you. To do that, we're going to break the Voluntary Act requirement down into two different components. First, the requirement of an act, and then second, the requirement of voluntariness. By breaking things down in this way, we're going to develop a clear understanding of what the Voluntary Act requirement is, and we'll also get a better sense of the types of problems you can run into in the course of analyzing whether the Voluntary Act requirement is met. So with that game plan in mind, let's start with the act requirement. In the criminal law, there must generally be an act to incur liability. But what's an act? Well, for the purpose of the criminal law, we can say that an act is a bodily movement, however slight. And that minimal definition makes the act requirement an incredibly easy one to meet. So for example, even the slightest movement of a finger, as in pulling the trigger of a gun in a homicide prosecution, will be enough. Indeed, even the movement of a person's tongue, for example, speaking words in a terroristic threats prosecution, would also be enough to satisfy the act requirement. What would not be enough is merely thinking about committing a homicide or thinking about making a terrorist threat. To illustrate, let's imagine 4 different people who separately would like a random guy named Bob to die. There's Alejandra, Brad, Carmen, and Dora. So the first person, Alejandra, fantasizes about killing Bob 1 time. The second person, Brad, repeatedly fantasizes about killing Bob and thinks of himself as a Bob killer. The third person, Carmen, specifically intends to kill Bob and devises a mental plan to do so in her head, but then goes no further. The fourth person, Dora, devises a mental plan to kill Bob and then carries it out, doing everything necessary to kill Bob. Okay, so on these facts, only Dora has engaged in a bodily movement in her effort to kill Bob. So under the act requirement, only Dora can be punished. This might seem pretty intuitive, but it's important to note that limiting criminal punishment to bodily movements is a policy choice that jurisdictions make, not a fundamental law of nature. It's easy enough to imagine a society that punished people in the absence of a voluntary act based solely on their mental activity. For example, Alejandra might be punished for her morally objectionable fantasy. Brad might be punished for fully embracing his Bob killer identity. And Carmen might be punished for mentally devising her wrongful plan to kill. And yet, for both utilitarian and retributive policy reasons, Anglo-American criminal law has decided against these possibilities and embraced the proposition that no one is punishable for their thoughts or status. In the United States, there's also a constitutional dimension to this requirement. In a case called Robinson v. California, the U.S. Supreme Court held that it constitutes cruel and unusual punishment under the 8th Amendment for a state to make it a crime to merely be addicted to the use of narcotics. In striking down a criminal statute prohibiting the mere status of being a drug addict, the court recognized that the government is always free to criminalize using, possessing, or being under the influence of an illegal drug. At the same time, the court also concluded that the 8th Amendment to the U.S. Constitution requires proof of something more than mere status. To prosecute someone for the state of being addicted to a substance, the Robinson court reasoned, would be like prosecuting someone for simply being sick. And to do that, the Robinson court concluded, would violate the constitutional guarantee against cruel and unusual punishment. Okay, so that's the act component of the Voluntary Act requirement. Now, let's consider the voluntariness component. The most important thing to know about the requirement of voluntariness is that the word voluntary doesn't necessarily mean what you might think it means. Because in the criminal law context, use of the term voluntary doesn't follow everyday conversation. Instead, voluntary is a term of art with a very specialized meaning. For purposes of this class, voluntary means willed, understood in the terms of an act being the product of conscious effort and determination. This definition of voluntary includes speech, since your vocal cords don't move on their own. Instead, speech usually requires conscious effort and determination by the speaker. And this definition of voluntary also includes many other bodily movements whenever they're willed by the actor who engages in them. One way to think about this legal definition of voluntary is as follows. An act is willed, or the product of conscious effort and determination, if it's controlled by the mind of the actor and not merely by an actor's brain. Say what, Professor Sirota? Well, let me illustrate with an example. Think about the difference between someone who says, I raised my hand, versus someone who says, my hand just came up. In the first case, the speaker is suggesting that she chose to raise her hand, that it was a decision she made, which was the product of conscious effort and determination. By contrast, in the second case, the speaker implies that her hand rose unwillingly, without conscious effort and determination on her part, in which case the rising of her hand wouldn't count as voluntary. The same idea is baked into the difference between a wink and a blink. That is, someone chooses to wink their eye, just like they choose to raise their hand. Whereas a blink usually isn't willed, because again, it's not the product of conscious effort and determination. And so a blink would count as involuntary for purposes of the criminal law. Okay, so aside from blinks and phantom hand risings, what other acts does the law consider involuntary? Well, one important category of involuntary acts are reflexes, which is to say, autonomous neurological responses that people have to external stimuli. Imagine you go to the doctor's office and the doctor hits your knee with a mallet. Then your foot comes up and kicks your doctor in the face. Now, that would definitely be unfortunate and maybe also hilarious, but it probably wouldn't be criminal. Another uncontroversial category of involuntary acts would be convulsions. That is, generally speaking, acts committed during seizures are also viewed by the criminal law as involuntary. So far, so good? I hope so. Now let's consider some more controversial examples of involuntary acts. Those are acts committed while sleepwalking and acts committed in a state of hypnosis. Some jurisdictions view acts committed while sleepwalking or under a state of hypnosis as involuntary, on the basis that they're not the product of conscious effort and determination. At the same time, other jurisdictions take a different view, on the theory that one would never do something while asleep or under hypnosis that one would not otherwise do in a normal waking state. Given this split of opinion, criminal liability for sleepwalking or hypnotic acts may depend upon the specific jurisdiction in which those acts are committed. So for those sleepwalkers out there, you might want to take a look at the criminal code before you start counting sheep. Okay, so those are involuntary acts from the criminal law's perspective. Now, I want to consider some kinds of conduct that the average person on the street might think of as involuntary, but which the law considers to be voluntary. Again, because they're the product of conscious effort and determination. So one category of such acts are acts committed in a state of duress. Consider the following hypothetical. Alicia tells Barney, either you rob that store and give me the proceeds or I'll kill you. Intending to save his life, Barney grabs a gun and instructs the owner of the store to place all the money in a bag. Then, holding a large bag of cash, Barney walks out of the store. Now ask yourself, has Barney acted voluntarily under the voluntary act requirement? If you can, pause the recording for a moment to reflect. Okay, welcome back. So, as a matter of common sense, you might think that someone like Barney, who is effectively coerced to do something, was acting involuntarily. But the law takes a different view. Because Barney's muscular contractions in robbing the store were willed acts, which were the product of conscious effort and determination. So therefore, Barney's conduct would satisfy the voluntary act requirement. And that's true even though Barney's conduct may have been motivated, indeed we could say compelled, by a set of circumstances beyond his control. Compelled acts may still be willed by the actor, and when they are, they still satisfy the voluntary act requirement. However, it's important to note that just because Barney's act was voluntary doesn't mean he can be convicted of a crime. As we'll learn later on this semester, there's a special criminal defense called duress, which excuses people who've been coerced into committing crimes. But the important thing to recognize for now is that actions performed in a state of duress are considered voluntary in the eyes of the criminal law. Another area where the legal definition of voluntary departs from the everyday usage are acts committed in the absence of mens rea or the guilty mind, which is another general requirement of liability we'll learn about more in the next class. But for now, consider this hypothetical. Charlotte is shooting at a target range trying to hit a bullseye. So Charlotte loads her gun, aims at the bullseye, and then pulls the trigger. At the very moment that Charlotte's pulling the trigger, someone named David jumps in front of the target and ends up being fatally shot. Now ask yourself, has Charlotte, in shooting David, acted voluntarily under the Voluntary Act doctrine? If you can, pause the recording for a moment to reflect. Okay, welcome back. The correct answer to the question is yes, Charlotte has acted voluntarily under the Voluntary Act doctrine. And that's because Charlotte's muscular contractions in firing the gun, which shot David, were willed acts that were the product of conscious effort or determination. As a result, her conduct satisfies the Voluntary Act requirement. Here again, though, it's important to note that just because Charlotte's act was voluntary doesn't mean she can be convicted of a crime. As we'll soon learn, another fundamental requirement of criminal liability is mens rea, or the guilty mind. And under these circumstances, it seems pretty clear that Charlotte lacks mens rea. For present purposes, though, it's important to note that the requirement of mens rea is distinct from the requirement of a voluntary act. And most forms of conduct that occur without a guilty mind remain voluntary, as that term is understood by the criminal law. Okay, so one final kind of act the law considers to be voluntary, but which common sense may not, are habitual acts. Consider another hypothetical. Fernita routinely speeds down the same street on her way to work because she knows that the police never monitor that street. After years of doing this, speeding becomes habitual for her. Then, one day a decade later, Fernita is engaged in her habitual speeding routine again when she finally gets arrested for driving too fast. Under these circumstances, Fernita can't escape liability by claiming that her conduct was involuntary, even if it was in some sense automatic. Because from the perspective of the criminal law, acts done out of habit are still considered to be voluntary, because again, they're still the product of conscious effort and determination in some minimal sense, even if the defendant failed to give it much thought before engaging in it in a particular place. Okay, so that's a general overview of the Voluntary Act requirement as it currently applies in U.S. criminal law. Now, I want to take a moment to discuss where the Voluntary Act requirement comes from. Like many of the criminal law's basic ingredients of liability, the Voluntary Act requirement has been around for a long time and was first recognized by courts through judicial decisions more than a century ago. Which is to say, the Voluntary Act requirement was originally developed through the common law. But more recently, many state legislatures have codified the Voluntary Act requirement in general legislative provisions adopted during the wave of code reform efforts that were inspired by the Model Penal Code. As a result, most legislative codifications of the Voluntary Act requirement are based on language proposed by the Model Penal Code. Take a look at the MPC text contained in the back of your casebook for Section 2.01, and you'll soon discover the following language. First, 2.01(1) states in part that a person is not guilty of an offense unless his liability is based on conduct that includes a voluntary act. This establishes a general requirement of a voluntary act. But what exactly is a voluntary act? The closest thing to a definition we get is contained in subsection 2, which states, quote, "The following are not voluntary acts within the meaning of this section. A reflex or convulsion. B, a bodily movement during unconsciousness or sleep. C, conduct during hypnosis or resulting from hypnotic suggestion. D, a bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual." Okay, what's going on here? Well, instead of an affirmative definition of a voluntary act, the Model Penal Code is offering a list of involuntary acts. However, that list is then bookended by a negative catch-all definition in Provision D, which references, quote, "a bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual." This is, in effect, a negative and confusing way of stating the affirmative definition of voluntariness I gave you earlier in this lecture, that a voluntary act is a bodily movement that is the product of conscious effort and determination. And so if you're ever asked to apply MPC Section 2.01, you should feel free to cite to Provision D as the basis for that affirmative definition. But okay, so how is this MPC definition any different than the general common law principles we've been discussing? The short answer is, it really isn't that much different at all. The drafters of the Model Penal Code generally attempted to codify the pre-existing common law at the time and to turn it into a comprehensive legislative provision on the Voluntary Act requirement. So if you were asked to analyze a fact pattern for voluntariness, it would make almost no difference whether you were asked to apply the common law or to apply Model Penal Code Section 2.01. Why do I say almost? Well, do you remember how earlier in the lecture I mentioned a split in opinion regarding whether acts committed while sleepwalking or in a state of hypnosis count as involuntary? Okay, so now I want you to take a look at Model Penal Code Section 2.01(2) and see if you can figure out the code's perspective. If you can, pause the recording for a moment to reflect on the issue. Welcome back. As you may have noticed, Model Penal Code Section 2.01(2) states that a bodily movement during unconsciousness or sleep, or conduct during hypnosis or resulting from hypnotic suggestion are involuntary. So in effect, the MPC resolves the common law split in opinion and takes a side of the involuntary camp. So if you were asked to analyze a sleepwalking hypo under MPC Section 2.01, then the governing law would be clear and your analysis would be straightforward. But if you were asked to analyze that same hypo under common law principles, then you'd want to mention that your answer would depend upon which of the two different approaches a given jurisdiction subscribes to. Okay, so here's something to know about this class. You don't need to memorize some general abstract common law principles, and I'm not going to ask you to apply them, because this class is statutorily based, just like the real world of criminal practice. So I'm always going to give you statutes to apply. Often, I'll just ask you to apply the Model Penal Code. But sometimes I'll give you a statute that incorporates different legislative approaches, codifying common law policies that conflict with the Model Penal Code. And there, you're just responsible for reading and understanding the statute. Here's an example of what I'm talking about. Imagine I asked you to analyze a fact pattern under a voluntary act statute that looks just like Model Penal Code Section 2.01(2), but which omits the clauses on sleepwalking and hypnotic acts. That is, the language for this statute I've given you is identical to the Model Penal Code, except that provisions B and C are missing. So this isn't merely a hypothetical. Some jurisdictions with MPC-based voluntary act provisions have enacted something like this. But why? Well, these jurisdictions wanted to adopt clear legislation on the topic of voluntariness, which the MPC offers. But at the same time, these jurisdictions disagreed with the MPC's specific policy recommendation to exempt sleepwalking and hypnosis situations from criminal liability. This is a recurring theme that we'll encounter throughout the semester. State legislatures adopting criminal statutes based on the MPC, but which make statutory modifications based on policy disagreements with the American Law Institute. In these situations, the most important thing to know is that the actual legislative text adopted by legislature is what governs, and not the MPC's specific policy recommendations when those recommendations haven't been enacted into law. So in the case of the modified voluntary act statute I just described, you might argue that by omitting the MPC provisions on hypnosis and sleepwalking, the legislature likely intended to treat sleepwalking or hypnosis as voluntary, contrary to the recommendations of the American Law Institute. So look, if this sounds a bit challenging, don't worry. We'll spend a lot of time discussing and working through these kinds of issues throughout the semester. For now, the most important thing to know is that in the real world, criminal law is statutorily based. And most real-world criminal statutes incorporate a mix of common law and MPC elements. So in this class, we'll pay special attention to figuring out what those elements are based upon careful readings of statutory text. Is this sometimes challenging? Sure. But can you learn how to do it? Of that, I'm absolutely certain. Not only because of how bright you are, but also because it's what the law requires, not only in criminal contexts, but in many other practice areas that are also statutorily based. So I know you can learn how to do it, and I'll be here to help you every step of the way. Okay, so those are the basics of the voluntary act requirement, which is a fundamental element of criminal liability. Across most cases, this requirement will be satisfied by proof of a will bodily movement, which is the product of conscious effort and determination. I say most because, like most areas of law, there are exceptions to every rule, and that's also true when it comes to the voluntary act requirement. In the next part of this lecture, we're going to discuss how, under certain circumstances, voluntarily failing to engage in an act, or what we'll call an omission, can also provide the basis for criminal liability. But before we discuss what those special circumstances are, I want to first begin by describing for you the criminal law's general approach to dealing with omissions. And that approach goes like this. Ordinarily, a person is not guilty of a crime for failing to act, even if that person's failure to act permits harm to occur to an innocent victim. And even if the person could have helped this innocent victim with no risk to their own personal safety. If that sounds cold, that's because it is. Let me illustrate. So look, I know that you're a kind and caring person. Indeed, I can feel your love and altruism from here, projected through the screen. So for this hypothetical, I need you to imagine an evil, heartless version of yourself that has no love for anyone or anything aside from, baseball. Now I want you to imagine this evil version of yourself is walking to a baseball game when you walk by a shallow pond that a small child is playing next to. You see the child slip and fall into this pond, at which point the child begins drowning. You look around, and you notice that there's no parent in the vicinity, and recognize that you're the only person who can help this child. You also quickly realize that with about 30 seconds of your time, you can walk over to the pond, pull the child out, and save their life. But that would require you to be 30 seconds late to the baseball game, which is the only thing that you care about in life. So you shrug your shoulders and walk away, allowing this innocent child to drown in the pond. Arguably, your unwillingness to expend 30 seconds to save an innocent child's life makes you a moral monster. But it wouldn't necessarily make you a criminal for a couple of reasons. First, criminal liability typically requires a voluntary act, and there is no voluntary act here. Second, there's no general duty to aid other people or to report a crime. So in this case, the evil version of yourself couldn't be prosecuted for murder, even if you were clearly aware that doing nothing would result in the child's death. In other words, the criminal law's general perspective is that you can be as curmudgeonly as you want. You don't have to lift a finger to help people. You don't even have to call 911 or let the police know what's happening. Certainly, as human beings, we have moral duties to aid, to report, and to help other people. But the violation of moral duties to act generally don't give rise to criminal liability. However, there's an exception to both a voluntary act requirement and this general prohibition against omission liability. And that occurs where there are failures to act in the face of a legal duty. So the general rule is that an omission which violates a legal duty can provide the basis for criminal liability, provided the actor was physically capable of fulfilling that duty. What does that mean? Well, let's illustrate by working with the most well-known legal duty, a parent's obligation to provide their children with reasonable care. Parents have a common law responsibility to ensure that their children have food to eat, the medicine they need, and are generally kept out of harm's way. And so, if a parent's failure to act violates this legal duty of care and results in a criminally prohibited harm, well then that omission can provide the basis for criminal liability. Consider, for example, the pond hypothetical we just discussed. Imagine that the evil version of yourself also happens to be a parent, and that the child drowning in the pond is your child. In that case, the analysis we just did shifts, because you'd now be legally obligated to make reasonable efforts to save your child's life. And so if you just watched your child drown, aware that you're failing to do so would result in the child's death, well then you could be prosecuted for murder. True, you wouldn't have engaged in a voluntary act, but you would have engaged in a voluntary omission, understood in terms of failing to fulfill a legal duty that you were physically capable of fulfilling. By contrast, if you became paralyzed at the precise moment your child started drowning, well then your omission wouldn't have been voluntary. That is, you wouldn't have been physically capable of giving your child the care she needed in that moment. So then, for purposes of criminal omission liability, the key question is, when does someone have a legal duty to act? Generally speaking, and for purposes of this class, legal duties to act arise from two different sources. The first, and most simple, are criminal statutes which specifically criminalize failures to do certain things. So for example, some statutes make it a criminal offense to fail to pay your taxes. Consider the following offense. A person who knowingly fails to pay his or her federal taxes shall be punished up to 5 years in prison. Or consider a statute which specifically criminalizes negligently failing to provide food and shelter to one's child, thereby placing them in significant danger. These statutes expressly create crimes of omission, and in so doing, create legally enforceable duties on people to do things. So when people violate these duties by falling within the express terms of these kinds of statutes, there's no problem with holding them criminally liable. Let's call this the crime of omission exception to the voluntary act requirement. This exception can be contrasted with the situation of someone who is prosecuted for violating a standard criminal statute, phrased in the affirmative, based on their failure to live up to a more general legal duty. Consider, for example, the evil parent version of the drowning child hypothetical we just considered. Parents are generally obligated to care for their children, and so a voluntary failure to save one's child from drowning can provide the basis for an assault conviction, which prohibits knowingly causing bodily injury to another person, in the event the child suffers bodily harm. Or the parent's failure to save their child from drowning could provide the basis for a murder conviction, which prohibits knowingly causing bodily injury in the event the child dies, provided again that the parent was physically capable of living up to their general legal duty of care. Given these dynamics, the key question in a lot of omission situations becomes, is there a general legal duty to aid? And where do those duties come from? Generally speaking, these legal duties come from the common law, which recognizes a duty to aid in four main situations. The first situation is where there is a status relationship, which is usually based on dependency or interdependency. Under the common law, a person has a general duty to engage in reasonable efforts to care for and protect someone with whom they have a special status relationship. Illustrative examples include spouse to spouse, employer to employee, and as we just discussed, parent to child. The second situation is where a person has an express or implied contract to come to the aid of another, such as, for example, where a babysitter has an express or implied contract to protect the person they're babysitting. Imagine, for example, that the evil version of yourself was not the small drowning child's parent, but rather the small drowning child's babysitter. Well, in that case, the common law would recognize your contractual obligation to care for the child, in which case your failure to save the child from a drowning would violate your legal duty to aid. And so you could also be prosecuted for murder, that is, knowingly causing the death of the child, for your voluntary omission act. All right, the third situation in which the common law recognizes a general duty to aid is through the voluntary assumption of care. So, under the law, you're not required to be a good Samaritan. However, the law does require a good Samaritan who voluntarily assumes the care of another to continue assisting the person if a subsequent omission would place the victim in a worse position than had the good Samaritan not assumed the care in the first place. All right, that may sound like a mouthful, so let me illustrate. One day, Dina's driving and sees a cyclist named Victoria lying on the side of the road injured. Dina puts Victoria in her car and takes her home to provide care. While living at Dina's, Victoria develops a critical illness. Dina does nothing to help Victoria with this illness, for example, like calling a physician, and as a result, Victoria dies. On these facts, Dina could be held criminally liable for Victoria's death. True, Dina did initially have a duty to help Victoria when she was injured on the side of the road. But after taking Victoria home, assuming care, and secluding Victoria so that Victoria couldn't get help from anyone else, well then Dina had a general duty to assist Victoria with dealing with the critical illness she subsequently developed. The fourth situation where the common law recognizes a general duty to aid is a situation of risk creation. Where one person creates a risk of harm to another person, they become obligated to prevent subsequent harm from occurring. So for example, imagine driver David strikes pedestrian Vincent with his car in a secluded area, causing moderate injury to Vincent, who's now lying on the side of the road. Under these circumstances, David now has a duty to come to Vincent's aid, the violation of which could provide the basis for subsequent liability. So for example, imagine that instead of helping, David simply leaves Vincent on the side of the road, who's thereafter fatally hit by another car, the driver of which didn't see Vincent lying there. Well, in that case, David may be held criminally responsible for killing Vincent based on his violation of a legal duty to care, which was created when he initially created a risk of harm to Vincent. Okay, so we've now discussed four situations in which the common law creates a general legal duty to aid: status, contract, voluntary assumption of care, and risk creation. Before concluding, I want to mention one final source of general legal duties to aid: civil statutes. That is, when a civil statute creates a general duty to aid, the violation of that general statutory duty can provide the basis for omission liability. Consider, for example, that in most jurisdictions, there are statutes that specifically require police officers to come to the aid of members of the public. Well, in that case, a police officer's violation of that legal duty could provide the basis for criminal omission liability in the same way as our other examples. Okay, so that's a general overview of the law of omissions. Prior to concluding our discussion of the topic, I want to discuss where this law comes from. Just like the Voluntary Act requirement, these omission principles are rooted in the common law and have been codified by state legislatures based on the recommendations of the Model Penal Code. To understand what the MPC has to say on the topic, let's return to section 2.011, which states in full that, quote, a person is not guilty of an offense unless his liability is based on conduct that includes a voluntary act or the omission to perform an act of which he is physically capable. Okay, so the bolded language on the screen establishes that the omission to perform an act that someone is physically capable of performing can provide an alternative to the Voluntary Act requirement. But wait, does that mean that any omission will suffice for criminal liability? Not so fast, as the MPC goes on to clarify in section 2.013, which establishes the following, quote, liability for the commission of an offense may not be based on an omission unaccompanied by action unless A, the omission is expressly made sufficient by the law defining the offense, or B, a duty to perform the omitted act is otherwise imposed by law. Okay, so this provision codifies the omission principles that we've been previously discussing. That is, under the MPC, criminal liability cannot attach for omissions unless one of two things are true. First, A, the omission must be expressly made sufficient by the law defining the offense. This is basically the crime of omission exception to the voluntary act requirement we just discussed. Then, B states, a duty to perform the omitted act is otherwise imposed by law. This latter provision refers to the 5 situations we just discussed in which criminal liability can be based on general legal duties. So, in short, there's no difference between the common law and the MPC approach to omission liability. Model Penal Code Section 2.011 and 3 simply codify the common law principles of omission liability in a clear and comprehensive way. And that brings us to the end of today's lecture and our first real exploration of black letter criminal law. So with that in mind, before signing off, I want to pause to briefly recap what we learned in this lecture. Okay, so in the criminal law, the existence of a voluntary act is a fundamental general requirement of liability. That requirement is satisfied where someone charged with a crime is being prosecuted for conduct that involves a will bodily movement, understood in terms of a bodily movement that's the product of conscious effort and determination. This requirement generally precludes reflexes and convulsions from being the basis for criminal liability, and some jurisdictions afford the same treatment to acts that occur while sleepwalking or which are the product of hypnosis. So while this requirement of voluntary act is a fundamental ingredient of criminal liability, there's also a limited exception that exists. Failing to act under circumstances where an actor is under a legal duty to act and has a physical ability to live up to that duty. But how do you know when those circumstances exist? Well, for one thing, where a statute expressly criminalizes failing to act, a person is under a legal duty to act. So for example, if a statute makes it a crime to fail to pay your federal taxes, well then there's no problem holding someone criminally liable for failing to do so, provided they're physically capable of performing the movements necessary to pay their taxes. Beyond this crime of omission exception to the voluntary act rule, people can also be held criminally liable for violating general legal duties to act, which arise under 5 kinds of situations. The first 4 rooted in the common law: status, contract, voluntary assumption of care, and risk creation. The 5th and final situation is where a general legal duty is created by a civil statute. So that's a summary of the black letter law we covered in this recording, which is clearly codified by Model Penal Code Section 2.01 and the many state codifications based on this voluntary act provision. I'll have more to say about this black letter law and the MPC in class, but for now, you have what you need to begin the readings and to work through your class assignments. So with that, I wish you the best as you continue your march down the path of substantive criminal law. See you soon.